Hi, Assalamualaikum warahmatullahi wabarakatuh. We are from Group T, and our topics today is essential element of contract. This is our group member, Syafriman Shazwan, Nur Aliyah Maisara, Muhammad Aiman Firas, Muhammad Ari, and Khalish Ilman Ali. Okay, introduction. Contract law governs agreement between parties defining their right and obligation. It covers everything from daily transactions to complex deals, providing clarity and enforcement mechanism. Rooted in common law and statutes, it includes key concept like offer, acceptance, and consideration, ensuring predictability and fairness in legal dealings. Next, intention to create legal relation. Intention to create legal relation means refer to the willingness or intention of parties to a contract to be bound by the legal consequence of the agreement. In simpler terms, it means that the parties involved must have a genuine intention to enter into a legally binding contract rather than merely engage in a casual or social agreement. This concept is crucial in contract law because not all agreements between parties are intended to create a legal relation. For a contract to be enforceable by law, there must be evidence that the parties intended to be legally bound by the agreements. Next.
Now, we will be taking a look at some of the factors that indicate an intention to create legal relations. The first one we have is express terms. The language used in this agreement may explicitly state the intention to create legal relations. For example, using phrases such as "this agreement is legally binding" or "subject to contract" indicates an intention to be bound. The best example I can give you of what an express term is like, okay, imagine you and your friend want to trade toys. You both talk about what toys you're going to swap, how long you can keep them, and if you need to give them anything extra, like stickers, for example. These are like rules you agree on when you play a game. These rules are called express terms. They make sure everyone knows what to expect and nobody gets confused or upset later on. The second one we have is nature of agreement. The nature of agreement itself can indicate whether the parties intended legal consequences. Business agreements or services are more likely to involve an intention to create legal relations compared to social or domestic arrangements. The best way I can, explain this to you guys is the nature of agreement. As an example, is like what kind of agreement it is and what it's all about. It's like knowing you're playing a game or having a serious talk. For example, if you and your friend agree to trade some playing cards or something like that, that's a simple agreement about toys. But if your parents signed a contract to buy a house, that's a big serious agreement about property. So the nature of the agreement tells us what it's for and how important it is. Next up, we've got consideration. The presence of consideration in a contract refers to something of value exchanged between the parties. It's an indication of an intention to create legal relations. Consideration demonstrates that the parties bargain for something in exchange for their promises, suggesting seriousness and intent. Consideration simply is like the give and take in a deal. It's what each person gets out of the agreement. For example, if you promise to give your friend a toy in exchange for the stickers, the toy and the stickers are the considerations. Both sides have to give something for the deal to be fair and legally binding. So consideration is what makes a promise or agreement more than just a friendly chat. It is what makes it a real deal. So think something like, for example, if you're going to buy a car or a house, yeah, the offer is probably going to get money, and you're probably going to get the house or the car, for example. Yeah. Next up, we've got the formality of the agreement. Formal agreements are drafted by legal professionals or documented in writing. They're more likely to indicate an intention to create legal relations than informal verbal agreements or agreements made in a social setting. Simply explain, the formality of an agreement is like the way you make a promise or a deal official. Sometimes just saying you'll do something isn't enough. Like, let's say I want to give my house to my son or my wife, something like that, for example. But before I do any of that, I need to sign, write it down somewhere or follow some specific rules that have been laid out by the government. And they usually sign a lot of papers and follow certain legal steps. That's because big promises like buying a house need to be taken seriously and done in a certain way to make sure everyone understands and agrees. So the formality of an agreement is all about making it official the right way. That's the easiest way I can explain. Then finally, we've got past conduct. Past conduct is basically the parties' past conducts or dealings may provide evidence of their intention to create legal relations. If parties have a history of entering into legally binding agreements, it supports the presumption that they intend to enter the current agreement to be legally enforceable as well. Past conduct is basically things people have done in the past that can help understand what they might do in the future. In legal terms, it's like looking at someone's history of actions to predict how they might behave in a similar situation. For example, if someone has always paid their rent on time in the past, their landlord might trust them to continue doing so in the future. Similarly, in a business agreement, if two companies have worked together well before, they might be more likely to trust each other in future deals. So, past conduct helps us make informed decisions by looking at how people have behaved in the past. Yeah. In summary, an intention to create legal relations is a fundamental principle in contract law that distinguishes enforceable contracts from non-binding agreements. It ensures that parties enter into agreements with a clear understanding of their legal rights and obligations.
In Malaysia, one significant case related to intention to create legal relation is Chow Tiong Hin and ORS v. Chow Hok Swee 1959, 1 MLJ 67. The court ruled that agreement between a father and his adopted children to work on a family farm and business were not legally binding contract because they laid intention to create legal relation that case stemmed from family dispute over property ownership, with the adopted son claiming entitlement based on a alleged agreement with the father. Certainty means in contract law refer to a requirement that the terms of a contract must be clear, definite, and unambiguous. It ensures that both parties understand their right, obligation, and the scope of the agreement without any room for misunderstanding or confusion. Certainty is essential for a contract to be enforceable because it provides a basis for determining whether parties have fulfilled their contractual obligation and allow for effective resolution of dispute. Thank you.
So there is 5 aspects of certainty in contract law. So the first one is clear terms. The terms of the contract must be expressed clearly and precisely, leaving no room for interpretation or uncertainty. This includes identifying the parties involved, specifying the subject matter of the contract, detailing the rights and obligations of each party, and establishing any condition or contingencies. So the second one is definite agreement. So the contract must establish a definite agreement between the parties, meaning that there must be a meeting of the minds or mutual assent regarding the essential terms of the contract. Both parties must agree on the same term without any material discrepancy or disagreement. So the second one is identifiable terms. The terms of the contract must be capable of being identified and understood by both parties. And this includes using commonly understood language, avoiding vague and ambiguous terms, and providing sufficient detail to enabling performance of the contract. So the fourth one is absence of uncertainty. The contract must not contain any uncertainty or speculative terms that make it difficult to determine the parties' rights and obligations. Uncertainty can arise from ambiguous language, incomplete terms, or the presence of conditions that are too vague or subjective to be enforceable. So the fifth one is certainty of subject matters. The subject matter of the contract must be clearly defined and ascertainable. This ensures that the both party knows what is being contracted for and can be performed their respective duties accordingly. So overall, certainty is foundational principle of contract law that promotes fairness, predictability, and the efficient resolution of disputes. Contract that lack certainty may be considered void or unenforceable as they fail to provide parties with the necessary clarity and understanding to create legally binding obligation.
Uncertainty case in Malaysia that deals with certainty in contract law is the case of Affin Bank v. Dato' Ahmad Zahid bin Hamidi, 2005 3 MLJ 361. Affin Bank sued Dato' Ahmad Zahid bin Hamidi for monies owned under overdraft facilities secured by shares. The defendant claimed breaches alleging non-disclosure of share disposal by the bank and breach of collateral agreements. Triable issues included the existence of collateral agreements, share disposal, and compliance with banking regulations. The court allowed the defendant's appeal, emphasizing the needs for a trial to resolve the disputes. In conclusion, the law of contract forms are the backbone of legal system, regulating agreements and ensuring fairness in transactions. Its principles provide clarity and enforceability, allowing parties to negotiate with confidence. With its foundational concepts and flexible application, contract law continues to adapt to the evolving needs of society, facilitating commerce and upholding justice.